in front.
May I have your lordship's leave to mention, madam? My lord.
Yes.
My lord, the writ petition was filed by way of public interest litigation. Your lordship will remember regarding the enemy property where buildings had been built.
Yes.
In that matter, my lord, I had taken out 2 applications, categorically narrating that my property is not an enemy property. But that was tagged in the list of 10 properties which were given in that particular petition. Now, even pursuant to the orders passed by your lordships and the contempt that was taken out, the police have taken steps to demolish. From the list, your lordship will even find that if the property is an enemy property, definitely the 4th floor and the 5th floor being unauthorized will not fall in on an enemy property, my lord. So that
then somebody filed an appeal before the Honorable Supreme Court.
That was in relation to the enemy property itself.
Yeah.
But the property which I am.
So was your application listed on the last occasion?
No, your lordship, and that has not been due.
And what is the date we have given?
Next
for the matter?
date, I have to assert and I'll give to your offices, my lord. The next.
You give the number. Probably, see, advancing the matter may be difficult. Probably on that date we will include your.
But by that time they'll come and demolish my property. The 4th and the 5th floor.
Please give the details. Let us check up the file.
My lord, my lord.
My lord, at
Yes,
the
madam.
risk of being reprimanded by my lords, I'm mentioning a matter again, lordship.
We have not opened our mouth.
Lordship, this is that matter where the CBI has recommended that disciplinary proceedings should be instituted against me. Although before the CBI court, they have submitted a report that the proceeding should be closed. My lord, my client is suffering a lot, lordship. His retirement benefits are not being disbursed because of the pendency. He suffered
unwell.
2 cerebral strokes, cardiac disease, pulmonary disease. My lord, any day, lordship will take it up, lordship.
Who will appear for the? You're for the respondent.
I'm for the respondent, my lord. I was a
Granted an
writ
interim
petitioner.
order.
Yes, my lord. I'm suffering an interim
But
order.
learned additional solicitor general is appearing.
Yes, lordship.
But have you put them on notice?
I have served notice, lordship,
On whom?
on the advocate on record for the appellant, lordship. Amrita Pandey.
Then we have to list it one day for it's a original side matter
Original side, my lord.
to be mentioned, and then next Wednesday.
I'm deeply obliged, my lord.
It will come under the caption to be mentioned.
My lord.
Suppose they are not ready on that day, we'll
My
give me
lord.
a date convenient to both of you. We can.
As lordship direct.
Yes.
I'm deeply obliged.
Original side daily is matter item number 1.
Yes, my lord.
I am appearing for petition. My lord, your petitioner has opted the Vivad Se Vishwas scheme already and filed the form 1. And for further procedural action, the precedent condition is a withdrawal of appeal for further filing of the forms.
Give the file answer.
This appeal has been filed by the SEC under Section 260A of the Income Tax Act 1961. The Act, bracketed the Act, challenging the order dated January 11, 2024, passed by the Income Tax Appellate Tribunal, SMC bench, in ITA number 351 /KOL/2023 for the assessment year 2014-15. The learned advocate appearing for the appellant assessee has circulated a letter withdrawing this appeal. The said letter is placed on record and the appeal stands dismissed as withdrawn. The substantial question of law as suggested are left open.
Grateful lords.
Obliged, my lord. Item number 2.
My lord, we have submitted the letter.
In fact, we had admitted this appeal.
Yes, yes, my lord. It was admitted on 5th December 2022.
Yes, please come.
This is the order on the order.
Number-
Very additional order.
This appeal has been filed by the Commissioner of Customs, bracket appeals, Kolkata, under section 150 of the Customs Act
बाकी चार पे आ सकते
1961,
बाकी आरो
challenging
चार
order passed by Customs, Excise and Service Tax Appellate Tribunal, Kolkata, Eastern Zonal Bench, dated 25th/8/21. The learned advocate appearing for the appellant department based on written instructions dated 24th January 2025 from the department submitted that the tax effect involved in this appeal is below the threshold limit fixed by the central board, and therefore the revenue does not wish to pursue with the appeal. Full stop. The said submission is placed on record and the appeal stand disposed of on the ground of low tax effect. The substantial question of law which were admitted for consideration are left open.
Grateful.
Item number 3,
My lord, last occasion I indicate only one thing. My concern was that there is a circular. In the circular, there is an exceptional clause. If there is a refund, but this is the circular, may I hand over this? That I am not falling under the exception. That line may be included in the order because if it is a refund case, and in that event, if it is a recurring in nature or question of law is involved, then it can be agitated by the revenue
Correct,
authority. But since there is an instruction by the department,
Don't accept.
the presumption is that they have accepted that we are not falling under the exceptions. That is my
So that
contention.
has to be added, is it?
Yes.
Already. Matter has been listed under the caption to be mentioned. By order dated 11th February 2025, the appeal was disposed of on the ground of low tax effect. Mr. Sumak Basu, learned advocate appearing for the respondent assessee, submitted that the court may also record that the case on hand does not fall under any one of the exceptional clauses as contained
In
in para 2
Yes.
of the instructions dated 2/11/2023 issued by the Central Board of Indirect Taxes and Customs, Ministry of Finance, Department of Revenue. Accordingly, it is made clear that the case on hand does not fall under any one of the exceptional circumstances mentioned in para 2 of the instructions dated 2/11/2023. This order shall form part of the order dated 11th February 2025.
Grateful.
This one I will have to, I will give this one. আমাকে দিয়ে রাখবেন একটা circular.
item number 4,
But I'm appealing for the appellant. There's a delay of 103 days, my lord, filing the appeal.
Only 103.
Yes, my lord.
That Mr. Subhash Agarwal will not object. What is the matter?
My lord, so far, Mr. Kundolia is appearing with me, my lord. He has paid.
Who's appearing?
Vipul Kundolia is the reading me.
Senior advocate.
My lord, let the delay be condoned. Estimation of commission, my lord, should be.
on accommodation entries. He's a accommodation entry operator. And some estimation was done at 0.60%, which tribunal reduced to 0.15%. Because in earlier year, the department has accepted lower amount.
On what ground they accepted lower percentage?
My lord, at para number, page
my-
number 47, my lord.
This is
Page number 47, 7.1.
This is
12th line from the bottom towards middle, my lord, we notice that the assessment order referred by the learned AO was completed on 31st/12/2007, and almost after 7 years, the assessment proceedings in questions have taken place. It is also not in dispute that the
Page 46, 47.
47, yes.
page 47. 47, para 7.1 towards the middle, 12th line from the bottom. We notice that the assessment order referred by the learned AO was completed on 31st/12/2017, and almost after 7 years, the assessment proceedings in question have taken place. It is also not in dispute that the magnitude of accommodation entry providing business has also increased manifold. It is an established fact that if turnover increases, the rate of profit, which in this case is commission, declines. The learned counsel for the SSC referred to the finding of the learned AO referring to previous search carried out on 23rd/3/2006 has pleaded that there was another search in 2019 and the revenue authorities have themselves accepted the commission income for AY 14-15 on same transaction of use volume at 0.03%, that is 1/3 of 0.1%, as the SSC along with 2 other commission agents were involved in carrying out accommodation entries. We further notice that the Honorable Bombay High Court in case of Gold Star Finvest dealing with similar issue of estimation of income of entry provider confirmed the view of the tribunal, estimating the rate of commission income at 0.15%. The relevant finding of the High Court is reproduced below.
But what they say is, apart from that,
My lord.
they say taking into consideration settled judicial proceedings, they followed
Hello.
Bombay High Court judgment
Yes.
in the past as well as in the future. No, the income assessed in the hands of the assessee in the past as well as in the future. Find it reasonable to estimate at 0.
But that is what is the basis of this, no?
No. In the past, what was the percentage of commission?
That I have my lord then can give me. I will file the compilation. What has happened in the past and
Because tribunal has not.
The reference to 0.10%. That order, all these things have to be placed then.
But if your lordship kindly CIT's observation.
Because if the assessee on an earlier assessment year on an identical issue, the commission was judged much lesser, that can be an yardstick. Other than that, merely following the Bombay High Court may not be.
No, but my lord, he is referring to, tribunal is referring to, at my lord, page 47, last 5 lines. Learned counsel for the SSC referred to the finding of learned AO referring to previous search carried out in 2006 has pleaded that there were another search in 2019 and revenue authorities have themselves accepted the commission income for AY 14-15 on same transactions of use volume at 0.03%, that is 1/3 of 0.1%. So
Commissioner says the assessee could not submit any supporting evidence for lower rate of commission, but the accommodation entry was 7,646 crores.
So
All right, today we will condone the delay. Please come, sir.
my lord, 4 weeks time may be given so that I can file the compare.
This appeal has been filed by the revenue with a delay of 103 days in filing the appeal. We have perused the petition application filed under Section 5 of the Limitation Act, and we find that the explanation offered is acceptable. Accordingly, the application is allowed and the delay in filing the appeal is condoned. At the request of Mr. Subhash Agarwal, learned advocate appearing for the respondent assessee, let the appeal be listed for admission after 4 weeks. Leave granted to the respondent to file a compilation of documents which were placed before the learned tribunal.
Deeply obliged.
Item number 5.
Same madam. Same.
5, 6, 7, all same.
Serious.
Same number of days.
Yes, it's 103 days.
Same order, separate order,
Separate
but same order.
Grateful. Item number 8.
Yes.
Milord, this is my appeal, Milord. There's a Section 5 application. There's a delay of 701 days, Milord. This is that matter, Milord, where it went back in review and then came back, Milord. On the last occasion, Your Lordship had asked us to serve the advocates who had appeared on the matter. We have served.
Lordship, I am for the respondent SBI. I am led by Mr. Joy Shah. He is on the virtual mode.
Where is he?
Milord, I am.
Mr. Joy Shaga, senior advocate. No, on top. Oh.
1 minute. 1 minute.
So what do you say about the delay?
Milord, so far as the delay is concerned, Milord, in this particular matter, Milord, I'd like to use a small affidavit, Milord, with regard to the Section 5 application. Normally, Milord, we don't make this prayer in Section 5.
But this appears to be a technical delay, no? Because we granted liberty. They filed a review. Review was dismissed. Now they have filed 2 appeals. One against the order in the review application and one against the main order. Otherwise,
Milord, I will, of course, be. I'm sorry, Milord. Milord, I will, of course, be addressing Your Lordship, Milord, as to Milord, the maintainability of an appeal from Milord, an order of review. But that comes later, only after Milord, the delay is condoned. Now, Milord, so far as the delay condonation, Milord, time, Milord, I'll come up with a small affidavit, Milord, for the sake of form.
How much
Milord,
time?
I know what is the likely outcome of the delay condonation.
All right. How
Milord,
much time?
whatever time Your Lordship is pleased to, Milord. 7 days, Milord.
7 days. All right. We have heard so and so, so and so. The learned advocate appearing for the senior advocate appearing for the respondent submitted that he may be granted to file an affidavit in opposition to GA 1 of 2025, which is an application for condonation of delay of 701 days. Let such affidavit be filed within a week from date. Reply, if any, within a week. Give a date after 2 weeks.
Lordship.
Returnable on, Milord?
It's after some date.
Item number 9.
Deeply obliged, grateful.
Well, a modification application has been taken out by the respondent in a dispose of matter.
What is the modification they want?
Well, it amounts to review of Your Lordship's order. Your Lordship has disallowed our appeal.
Forthwith release and disburse an amount of 1 crore 65 lakhs.
Yes. Lordship's order is at page 45. Whatever page in it.
Page 45.
Lordship. Forty-five, 46 is the ultimate order. Now they have applied for further modification or which amounts to review of Your Lordship's order, which is not maintainable.
No, on the last paragraph, if you page 45, internal page 10, last 3 lines,
Lordship.
4 lines.
To seek the
Therefore, to
payment.
that extent, the order
And if
passed.
such application is filed, then they will consider.
Hmm.
And Your Lordship dispose of the appeal. Now he is seeking modification, praying that the amount should be disbursed. Now the modification has been taken out without any condonation of delay.
Modification is not maintainable.
Yes, that too in January 2025.
This application has been filed seeking for appropriate directions in an appeal which was disposed of by judgment and order dated 14th March 2023. In this application, the applicant seeks for appropriate directions to the officers/representatives to forthwith release and disburse an amount of rupees 1,65,92,000 along with interest calculated at 12% per annum on and from 14th March 2023 till the date of actual payment. The appeal having been filed under Section 130 of the Customs Act 1962 and was considered on the substantial questions of law raised by the revenue, and a final judgment has been rendered on 14th March 2023. Therefore, the question of modifying the order or issuing further directions in a disposed of appeal does not arise. Therefore, the application is dismissed as not maintainable. However, the dismissal of this application will not prejudice the applicant from invoking other remedies available under law.
Item number 10.
I appear for the appellant, my lord. Lord, I'm led by Mr. Moinak Bose. Lord, may I assist your lordship, Lord, Mr. Bose? Lord, this is an appeal arising out of a dismissal of a writ petition challenging a tender process. Lord, we participated in the tender. Our bids were rejected on the techno-commercial stage, which was part 2 of the tender, prior to opening of the price bid. My lords, in the techno-commercial stage, otherwise technically qualified bid was rejected on one ground. That price had been indicated by us in one of the annexures which has been uploaded. It's an e-tender, right? One of the annexures which had been uploaded by us on the website, wherein the clauses of the tender on the later on after the rejection, it came to our notice that the clauses of the tender provides that in the particular annexure which says price bid, the area where the price had to be quoted, we had to write the word quoted and not quote the price. My lord, this is a clause in the tender. Admittedly, my lord, the price was put in that form which had been uploaded in the annexure. Instead of writing quoted, the price was quoted. The application was uploaded. My lord, thereafter, on 8th of January, my lord, there is an email was received by the tenderer, by us, stating there are certain deficiencies. 5 deficiencies were pointed out on that email, saying that these are the documents, including integrity pact, which had not been signed by us, and please provide the signed copy of the integrity pact amongst other documents. My lord, I'll take your lordship to that email, my lord. My lord, I take your lordship.
Yes. I'll give you a moment. Yes.
Well, I think my junior has told your lordship that this is regarding dismantling of underground foundations and overground structures in an expansive site of ISCO. So, the scope of tender was that, my lord, all intending bidders are required to make a bid for this construction work, lowest L1. And my lord, the price determination clause under the tender says the price determination would be by way of a reverse auction. Well, this is a primary important reverse auction. So, my lord, in my respectful submission, reverse auction as provided in the documents, which is the notice inviting tender, indicates that all technically qualified bidders, whatever there is, well, there were 3 parts in the tender: part 1, part 2, and part 3. Part 2 was technically qualified documents which were required to be uploaded. This is a completely e-tendering. So based on the documents which we upload, if we technically qualified, all technically qualified bidders will be entitled to participate in reverse auction. Now, my lord, at the time of submission, we were also required to upload our prices, which is part of part 3. So the uploading happened simultaneously, part 1, part 2, and part 3. Now, my lord, reverse auction would mean here that all technically qualified bidders will have to match the lowest And if somebody goes beyond the lowest, like somebody is given 100, 150 and 200. So now the person who's given 200 is also technically qualified. So now he has the option, if he technically qualifies, to go below 100, which is L1. So L1 per se doesn't have a right, or in no right has accrued in favor, because it is a reverse auction mechanism. So my lord, disclosure of price, which is the factor here, my lord, was of no relevance. Now, my lord, this is where the learned judge completely misconstrued and misinterpreted the clauses of the agreement and came to a conclusion. I'll tell you, Lordship, what had happened factually. Now, when we uploaded, there were certain mistakes that we had made. Now, the tendering authority gave us a mail on the 8th of January 2025 saying that you have committed 5 deficiencies. Lord, kindly have a look at that document once first. Lord, 8th of, this would be page 352. Third volume, my lord, page 352. Third volume. This would be a mail from the Steel Authority of India. My lord, kindly allow me to place this. It says that, my lord, first paragraph refers to the scope of tender. Then, my lord,
the deficiency in the documents are listed below.
Correct. My lord, kindly now make a note of. First, allow me to place, my lord, serial number 1, which is serial number 5 of the checklist, with reference to format annexure 6 of the commercial volume 1 in submitted declaration. You have not included the declaration regarding no risk purchase action. Kindly include the same as per format and resubmit the declaration. This was deficiency 1. Now, my lord, interestingly, kindly have a look at deficiency number 4, serial number 4, which is serial number 14 of the checklist, semicolon.
No, in all this, you have been given an option to
rectify. Now, my lord, I want to indicate is for serial number 4. Here, I was also given the option to rectify. What mistake that I did in serial number 4 is that integrity pact, which is enclosure 2, has been submitted but not signed on all the pages as per requirement of tender. So an option has been given to me to resubmit the signed copy of all pages. Now, my lord, kindly read this with page 64 and 65. My lord, kindly take this, because this itself was a ground available to them to, my lord, disqualify me.
They did not do so.
They did not do so. Now, your lordship will kindly come to what happens on 24th of. So I have uploaded. I had no, because this is a e-platform tender. So whatever documents were there, I have uploaded. Now, my lord, this mail had come. I rectified the defect. They were happy with the rectification. Now, my lord, kindly come to the document which is 24th of January at page 356. I received this mail where I am informed that, my lord, kindly take, we are in receipt of your letters representing against the rejection. No, my lord, not this one.
Yes.
No.
Commercial, as per ITB, clause 11.2.5,
No,
there shall be no indication of price anywhere in the document that is uploaded.
It's 337.
And such offers are liable to be rejected.
My lord.
You have disclosed the price in part 2 of the bid, therefore the bid is rejected as per ITB clause 11. So on.
Correct. So now, my lord, your lordship will kindly see A technically nil. So, my lord, I have technically qualified. So a technically qualified bidder has been rejected. Why? Because of this. Now, my lord, show your lordship, my lord, what mistake that I have done.
Suppose this
My
is
lord.
a condition of tender.
No, I can appreciate.
No, the
So-
thing is,
My lord.
the deficiency
Yes.
checklist
Correct.
is a stage anterior to evaluating your whether your bid is techno-commercially acceptable.
Yes.
So there is no evaluation done at that stage.
Right.
It is sort of a ministerial act,
Yes.
saying that in fact, because they are a public sector, probably this option is given. The private sector need not give an option. And these are probably in their estimation or as per the terms and conditions, trivial mistakes. So thereafter only your bid document becomes mature for consideration. Upon consideration, they refer to clause 11.2.5, matters over.
So now I'm at 11.2.5. Now, what mistake did I do? And whether it was trivial? Now, whether when you pointed out the deficiencies.
But is it not a very serious issue?
No, that's what I'm
trying. When you are not prohibited from indicating the price,
yes.
If you indicate the price, because it will be in the public domain, probably the other bidders will be able to scan through.
No, I'll tell you. That's why I wanted to indicate to your lordship reverse mechanism irrelevant. Whatever quote price I have given. Kindly have a look at this.
He is the tendering authority.
Correct. So that
he will say, I will allow only people who will be able to walk with their hands, not with their legs.
So what I'm saying is you cannot approbate and reprobate at the same time. What you're saying, you have allowed me. No, my lord, kindly appreciate this. You have allowed me, despite you had the right to disqualify me. I did not give the integrity pact. I did not even sign it. You authorized me, allowed me to rectify. I did. At that point of time, you never told me.
Here also, when you affirm the affidavit, something is missing.
Correct.
The appeal is not dismissed.
My lord.
It doesn't come to the court. The stamp reporter
Yeah.
sees that and says, sir, please rectify the defect.
Right.
So it is at that stage.
So now I'll give you a lordship. I'm taking a cue from what fell from your lordship. Now, suppose, my lord, my prayers are required to given at the end of the petition. By mistake, I give the prayers at the beginning of the petition. Will your lordship dismiss that application?
No. If it violates the format prescribed on the appellate side rules, your petition will not be accepted.
No, that's what I'm trying to say. So your lordship could have given me, applied the discussion and given me to rectify that. Delete this portion.
This is irreparable.
No, I'll tell your lordship. That's what I'm trying to
reverse this issue.
No, I'll tell you, lordship. What is done is, no, my lord, what has happened is, there is a enclosure which I was required to say. I'll tell you, give your lordship that particular clause. It will become very clear where we went wrong. Now, if your lordship will kindly come to that.
There is that 11.2.5.
My lord, kindly come to page 56 first.
Volume 1.
Yes, madam. No, give me that first clause where we went from 13. This was a complete misunderstanding of the language of the tender. Here they are referring to this clause 11.2.5 at page 56. There shall be no indication of price anywhere in any document that is to be uploaded as part of technical commercial bid. If prices are indicated in any document that has been uploaded, such offers are liable to be rejected. Very well. Now, my lord, where did I go wrong? If your lordship kindly comes to page 30. No, where is this one? Page 37. My lord, kindly come to page 37 once. This is where I went wrong. Now, my lord, kindly take serial number 13. Unpriced copy of price bid to be submitted with the word quoted. So instead of giving the price, which I have already given in part 3, it's not that I have not given the price. I have already given the price in quoted, indicated the price in part 3. But here, what I was required to do is, I had to write the word quoted in that column. So if your lordship will read this with that page 234, this is the format. 234. So everywhere I had to write quoted instead of the price. So what we understood is, we had to write the price which we have already given. So what we did is, we've given the price again. In this entire document, we've given the price.
Clause 13 is very clear. Unpriced copy of price bid to be submitted with the word
quoted, where price is to be quoted, enclosure 1. So my respectful submission is, I did that. Now, this does not prejudice any of the bidders or the tendering authority. So you are penalizing me for a mistake. Now, I have made 5 other mistakes. You did not penalize me for that. But for this mistake, you penalize me. The question is, my lord, as a public authority, if today, my lord, kindly appreciate
that
this.
doesn't make a difference, suppose.
No, my lord.
It is purely a commercial transaction between
Yes.
both of you.
Yes.
They may be a government of India enterprise, a state government enterprise. That doesn't make this particular tender or what is it to be tested under.
No, if I had technically qualified, now I have been rejected. A technically qualified, not technically qualified, I would have said otherwise.
You initiate arbitration on that. That rejection was bad.
No, but because I cannot participate now,
No, you
because
can't.
because if I have technically qualified, you reject me for a ground which is absolutely, my lord, not an essential terms.
In fact, there were earlier view of the Supreme Court also.
Yes.
While rejecting an application for grant of license for petroleum products.
Correct.
There was a distinction drawn. I vaguely remember, like during the early 90s, there are a couple of decisions. They said which are essential conditions, which are non-essential. Then Supreme Court subsequently they said, who are you to say that?
Right.
It's up to the licensing authority, tender inviting authority to determine as to which are the conditions which are trivial or which has to be implemented, etc.
Right.
And the court cannot examine what would be the consequence of this mistake. Can we examine? That would virtually put ourselves in the shoes of the tender inviting authority.
Well, my respectful submission, judicial review in tender matters. If your lordship will
Very
see,
narrow.
well, if your lordship from Tata Cellular onwards, well, it has always been that whether the action of the tendering authorities, arbitrary, well, here we are only on arbitrary. Well, we say, well, today, admittedly, if you had not issued me the letter of 9th January, allowing me to rectify the deficiencies, 5 deficiencies, and 1, that is what I wanted to show you, 1 authorized them to disqualify me. Well, this is not even a rejection. That allowed me to disqualify me. Say that you have not signed the integrity pact. Sorry, you don't even qualify. Well, the rejection is post my qualification. I have a technically qualified bidder. So today, your lordship will see it creates a situation that if I am technically qualified and I have a right to participate in the price determination. In the reverse auction, I could have given less, so that it would have been inured to the benefit of the public at large. Today, a technically qualified bidder has been rejected. Why? Because I have made a mistake. And similar mistakes I had made, which you allowed me to rectify. So, where is the rationality in the decision-making process of the tendering authority? So this, on this perspective, my lord, I wish to rely upon one judgment of the Supreme Court, which went from the Calcutta High Court. A similar stand was taken by the single bench and the division bench of the Calcutta High Court. And thereafter, when it went before the Supreme Court, my lord, kindly take this, my lord. This is 2013, volume 10, Supreme Court cases, page 95. I wouldn't have said this, but if I was technically disqualified. If you have technically qualified me, so that means I have all the requisite qualification to participate, but I make a mistake. I'm going to kindly have a look at this. Well, this was a tender floated by the KMC authorities. Now, if your lordship will kindly come to paragraph 2 once. The 2 terms of the subject notice inviting tender, which are germane in the case in hand, are clause I and J. Now, my lord, kindly take clause I once, my lord. A declaration in the form of affidavit in a non-judicial stamp, such and such. Applicant is not barred, delisted, blacklisted by any government, department, government undertaking such and such, and the like government. And if any such incident is found at any point of time, the tender will be cancelled similarly without assigning any reason whatsoever. This was 1, and 2 was valid PAN, VAT, acknowledgement, and latest. Now, my lord, what fell for consideration is, if your lordship will see, paragraph 3, it must immediately be clarified so far as I is concerned, the learned single judge had thought it unnecessary to analyze its applicability and relevance, having come to the conclusion that a violation of J has been committed by the appellant company inasmuch as it had failed to file its latest income tax return along with its bid. This position has continued to obtain even before the division bench, as will be palpably clear from perusal of the impugned judgment. The division bench, despite noting clause J, has concerned itself only with the legal implications flowing from the alleged non-compliance of clause I. Then, my lord, if your lordship will kindly take once paragraph 5. The impugned judgment states that clause J cannot be viewed as a non-essential term and therefore should have been corrected before the submission of the tender. This seems to us to be chronologically or consequentially impossible, which was obviously meant was the failure to adhere to this term would render the bid non-compliant and therefore beyond the pale of consideration in toto. The division bench also opined that the appellant company could not be granted the indulgence to correct this error, as such facility was not available to the other bidders. In saying so, the division bench, it appears to us, has diluted its view that clause J is altogether inviolable. Then, my lord, kindly take para 7 placitum A at page 101. There's a sentence starting with furthermore. There are some instances of decisions even of a single judge which, having withstood the onslaught of time, having metamorphosed into high authority demanding reverence and adherence because of its vintage and following the contradiction of the strength of the bench. This is the significant characteristic of the doctrine of stare decisis. Then, my lord, Tata Cellular has been considered. Then, my lord, Siemens. And then, my lord, if your lordship will kindly now turn to para 11 once. With this brief analysis of the decisions cited at the bar, we shall now return to the essential factors that shall determine our decision. The two clauses that had been debated before us have already been reproduced by us. Well, the learned single judge observation has been recorded. Now, if your lordship will see, my lord, if your lordship kindly turns to paragraph 13, there was a letter rejecting the offer reads, at the bottom of that letter, before the commencement of para 14, your lordship will find, they said reasons for disqualification was company not having submitted its latest income tax return along with its bid. So this was the ground of rejection. Now, my lord, if your lordship will kindly take my lord, kindly take 14 months. So far as the first point is concerned, it needs to be dealt with short shrift for the reason that the courts below have not thought it relevant for the discussion, having in their wisdom considered it sufficient to non-suit the appellant company for its failure on the second count. It has, however, been explained by Mr. Vishwanathan, senior counsel for the appellant company, that at the material time, there was no blacklisting or delisting of the appellant company, and that in those circumstances, it was not relevant to make any disclosure in this regard. The very fact that the tendering authority in terms of the communication dated such and such had not adverted to the ground at all lends credence to the contention that a valid argument had been proffered had this ground been raised. Regardless of the weight, pittiness or sufficiency of the explanation given by the appellant company in this regard.
I think you can come to paragraph 18.
My lord.
The reason given by the Honorable
Yes.
Supreme Court
My lord.
as to why this could not have assumed the essential character.
Correct.
But I think, Mr. Bose, the law has developed much after 2013.
Yes. No, my lord, if your lordship.
2013, of course, you have the baseline or the foundation is Tata Cellular. Only 5 conditions. It is not as if he has exceeded his authority. There is a specific condition in the terms of
There
NIT.
is.
He has not committed an error of law. He has not, there is no breach of principles of natural justice, and he has not abused his power. And according to you, it is arbitrary or it is not a reasonable decision.
Right.
From whose viewpoint the test of reasonableness has to be adjudged?
But here,
So,
if
and,
you are, if you,
and the courts now, the recent trend is, I think you will be carrying the recent decisions also,
yes, well,
that it's not for the court under 226 to interpret the terms and conditions of a notice inviting tender. The person who invites the tender is the best person to explain what it means.
well, our only challenge is the
Next time he can
decision-making process.
Next time he can be careful.
No, may I just indicate this? I was not careful earlier also. So the 9th of January mail.
That is a discretion given by the authority inviting.
So here, my lord, discretion. The moment your lordship says discretion given, so would you apply your discretion selectively?
No, this is mandatory.
No, if your lordship will see.
Priced copy of price bid to be submitted with the word quoted.
Yes.
Where price is to be quoted in.
So that is what I wanted to show your lordship. There is another clause like this, which authorized them to reject, which mistake I had made. So if you, that authorized them not only to reject, to disqualify me. So the rejection would have come much later. That's what I wanted to show your lordship. Kindly take one page 65. Well, kindly take page 44. Well, kindly take 64 once. Which says tender may also be rejected. 20.12.8, bottom of page 64. Now, if your lordship see, one of the condition is, if your lordship turns to the next page, page 65, Roman 7. The signed copy of the integrity pact as at enclosure is not submitted with the bid. Now, if your lordship goes back to serial number 4, I did not do that. So this itself was a ground for my disqualification. You did not do that. So why this selective decision-making process? I could have understood, my lord, if you had not given me the chance to discuss, because there is no condition in the tender which requires you to give me an opportunity to rectify the defect. You have shown benevolence. So, my lord, why reject me for a mistake that I have made, which is otherwise irrelevant, because it's a reverse auction. Whatever, my lord, kindly appreciate this. I have quoted the price. What relevance is there for a qualified bidder in a reverse auction for quoting the price?
That we don't know, and we are
No,
not
because the price says reverse auction. Yeah, that's what I wanted to show you, lordship. Kindly have a take the reverse auction clause. Page, my lord, 44. Kindly take the reverse auction clause. 44, 24, 31. 11.3.9. My lord, kindly take this. My lord, it would be page 57. It is your condition. This is price discovery. 11.3.9. The bidders who are considered techno-commercially eligible. So, my lord, I am techno-commercially eligible. Shall only be considered for price discovery, which can be through reverse auction or through opening online bid. Irrespective of the mode of price discovery, the evaluation of bidders for determining L1 bidder will be based on methodology as mentioned in the tender document and rates quoted obtained during reverse auction or submitted online EPS portal. So the price determination award of contract based on technically qualified bidders would be what? Can you match the lowest L1 in the reverse auction? In the usual process, if it was L1, I would have understood that why did you disclose the price? And my lord, kindly see, in a e-portal, I am uploading, it doesn't go to the other tenderers. It only goes to you. So you are the tendering authority. You have seen that I have by mistake in the enclosure quoted the price. So it is with you. There is no, my lord, the price does not go, or it doesn't get, or the other bidders doesn't get to know the price. It doesn't go to the public domain at all. It remains with you. And in any event, since it is reverse auction, regardless of what I have quoted, suppose I have quoted an absurd figure. The moment I qualify, you cannot disqualify me because I'm an, suppose, my lord, your lordship will say, the lowest is 100. I have quoted 1000. Do I not have a right in reverse auction to come down immediately and say that I will offer you 99 less than the L1 bidder and get the contract? I am. There is no bar. That's what reverse auction is all about. Yes. That's your price determination clause. And my lord, interestingly, if your lordship once comes back to the letter by which I was first, that page 357, the first, no, I stand corrected, my lord. Yes. 356. If your lordship comes back to that, an opportunity was given to me. So I wrote back to them. 357. At the bottom of 357, I was given an opportunity to make a representation. The 24th of January letter.
Where is that opportunity?
Absolutely at the bottom. I stand corrected. 356. 356, your lordship, this is the letter of rejection.
Submit representation, so and so.
Right. So I did submit the representation that your lordship will find at 360. Now, what do I say? I specifically refer to this issue. Well, if I may just trouble your lordship once. First I say this was my, this is my lack of understanding of English language. We understood the clause incorrectly. Admittedly, we made a mistake. Then, my lord, kindly see our page 360.
You have said reverse auction mechanism.
Correct. My lord, kindly see. It is now come to an understanding. Then, my lord, kindly see in the event.
Then what happened to your representation?
Then, my lord, kindly see how they deal with it. This is at page 364. Apart from dealing with the reverse auction, what we've said, that because it does not prejudice anybody is immaterial, they have dealt with everything, basically paraphrased what they have said on the 24th of January.
You didn't participate in the pre-bid meetings. If your representative had participated,
all the more reason I should have been disqualified before 9th of January.
Yes, sir.
All the more reason I should. Why did you give me 9th of January?
So what is? You were reasonable once. Why don't you be reasonable for the second time? Is there?
Reasonableness with regard to asking them to the deficiencies pointed out, rectify it, etc. That was with regard to conditions which the employer considered to be non-essential. This is an essential condition. Essential condition. How? If your lordship kindly takes page 78. The courts have in 2022 decision, courts have said what is essential, what is non-essential is not for the court. Court is not rewriting.
That Mr. Bose knows.
Your lordship just pointed out. Now, kindly come to page 78, clause 38. This is instruction to bidders. Rejection. The bid shall be rejected under the following conditions. Kindly come to the last one, 7. Bids containing filled-up price in techno-commercial bid part shall be rejected. No option is left to us. If we allow him to change it, then we will be violating the terms of the tender ourselves. And why this is essential? Because all the three parts of the bid are uploaded, but not the price bid is not opened. It is kept secret. That is the reason why the requirement is you only mention I have quoted, nothing else, so that it may not influence the other bidders. Because it will influence other bidders, some may even be driven away by seeing the price. Or even they may form a cartel. Therefore, this is a
There are
very
chances that information will leak out from your office also.
leak out.
Leak out.
No,
See, the
no,
person
yes.
the person who does the economic, I mean, not commercial
Techno-commercial.
evaluation, he will not know what is there in part 3.
Yes.
If he knows what is there in part 3 at the part 2 stage, anything can happen.
Yes, anything can happen. Therefore, that's a very essential condition of the entire tender process. And for
I
that,
don't know if this tender document, in certain cases, when the initial scrutiny is done, it is not done by the full team of evaluators. It is done at a little lower level, where they can exercise option, call the bidder, make corrections, etc. Some cases will occur where photograph should have been enclosed, the photograph will be upside down, etc. There are things. Then comes the technical evaluation and commercial part. He has been technically evaluated to be right,
but not
in the commercial because he disclosed.
Yes.
Because this will impact stage 3.
Yes.
Definitely.
Definitely impact this.
What is the value of the tender?
It's about, I think, 70 crores.
70 crores.
So value means, again, my lord, everybody is giving their quote. So then reverse auction will decide.
We are not here to say what will be the consequence of disclosure. That is not for us. When the terms and condition of tender say uses the expression shall be rejected, there is no discretion vested.
Then kindly see read clause 39 also on the same page 78. Non-negotiable terms and conditions. Kindly see 3 B. Submission of online bids in 3 parts. The parts are not absolutely well demarcated things.
Segregated.
Part 1 is EMD. Second part is techno-commercial. Third part is price bid, specifically mentioning in the ITB that they will not mention the price.
11.25.
11.25 your lordships have already seen. 11.25 at page 37. No, sorry. No, I'm sorry. And in the instruction to bidders, there is another 11.25 which I need to show to your lordship. 11.25 at page 56.
Shall be rejected.
11.2.5. There shall be no indication of price anywhere in any document that is to be uploaded as part of techno-commercial bid. If prices are indicated in any document that has been uploaded, such offers are liable to be rejected. Next is
17.2.
Page
61.
Then page 57, 11.3.9. The bidders who are considered techno-commercially eligible shall only be considered for price discovery, not before that.
The 17.2.
Then 17.2 clause at page 61. 17.2 at page 61. The documents that will be uploaded the documents that shall be uploaded should not contain any indication of price, as price bid is to be filled up online in the e-tendering site. These are below the various provisions.
Now, what is the stage of the tender?
The price bid will not be opened.
No. It has been opened already.
No, it has not been. Price bid has not been opened.
All right.
Possibly because of the pendency of the procedure.
This intra-court appeal by the unsuccessful writ petitioner is directed against the order dated 5th February 2025 in WPO 68 of 2025. the appellant had participated in a tender, in a e-tender invited by the Steel Authority of India Limited, within bracket respondent, for dismantling of underground foundations and overground structures in the expansion site of IISCO steel plant, Burnpur. The issue which falls for consideration in this appeal, as well as that which was considered in the writ petition, lies in a narrow campus, namely, as to whether the rejection of the techno-commercial bid of the appellant was justified and in accordance with the terms and conditions of the notice inviting tender. The learned single bench, on perusal of the reasons assigned by the respondent, namely the tender inviting authority, held that there is a clear bar in terms of clause 11.2.5 for indicating the price anywhere in the document that is to be uploaded as part of techno commercial bid. Accordingly, the writ petition was dismissed. You have elaborately heard the senior counsel, Mr. Gupta. At the outset, we need to point out that the courts exercising power under Article 226 of the Constitution of India are not equipped or shall not interpret the terms and conditions of contract of tender in a manner to suit the conclusion of the court, as it is for the tender inviting authority to give an explanation or meaning to the various clauses.
I will achieve.
Please. It is not in dispute that the respondent, that the appellant participated in the tender, fully knowing well about the terms and conditions of tender. Therefore, it would be too late for the appellant to wriggle out of the obligations and conditions of the mentioned in the notice inviting tender. The sheet anchor of the argument of the learned senior advocate for the appellant is that when the bid document was after the bid document was submitted online, the same was verified, and an email was sent to the appellant on 8th of January 2025, pointing out six deficiencies, and the appellant was granted liberty to rectify the deficiencies which the appellant had done, and thereafter the bid was taken up for evaluation, and the bid was found to be technically qualified. However, with regard to whether the bid was commercially qualified, the respondent held that the same is not qualified, and rejected the bid, as the appellant had indicated the price while uploading the techno commercial bid. According to the learned senior advocate for the appellant, the respondents, having afforded an opportunity to rectify the defects by email dated 8th January 2025, the respondent ought to have also permitted the appellant to rectify this defect, and that would have been fair and reasonable on the part of the respondent, which is a public sector undertaking. The question is whether the subsidiary argument is that since the price bid is to be finalized by reverse auction mechanism, even assuming that the price was indicated at the techno commercial stage, it cannot impact on the price fixation, and therefore it is not an essential condition of tender. To examine this, we have carefully gone through the terms and conditions of the notice inviting tender. In the details of documents, as contained in page 4 of the bid document, in clause 13, it has been stated that unpriced copy of price bid to be submitted with the word inverted comma quoted where price is to be quoted in enclosure 1. This condition clearly states that the word quoted has to be used wherever price is quoted in enclosure 1, which would go to mean that the appellant should not indicate the price. Clause 11.2 deals with part 2 : techno-commercial bid in accordance with instruction to bidders stated in NIT. Clause 11.2.5 states that there shall be no indication of price anywhere in any document that is to be uploaded as part of techno-commercial bid. Full stop. If prices are indicated in any document within bracket that has been uploaded, bracket close, comma, such offers are liable to be rejected. In terms of clause 11.3.9, the bidders who are considered commercially eligible shall only be considered for price discovery. Clause 38 deals with rejection and uses the expression shall, inverted comma. Full stop. The bid shall be rejected under certain conditions mentioned in clause 38. And in terms of clause 7, Roman 7, small Roman 7, bids containing filled up price in techno-commercial part, within bracket part 2, shall be rejected. Thus, the terms and conditions of tender have clearly enumerated this condition, which is an essential condition, and there is no discretion left with the tender inviting authority, more particularly when the expression shall has been used in not only one place, but in many places in the terms and conditions of tender. Thus, the petitioner having participated, appellant having participated in the tender, accepting the terms and conditions as such, the question of now wriggling out of the obligation is impermissible. Therefore, we find no reason to interfere with the order passed by the learned single bench. Accordingly, the appeal fails and is dismissed. Next.
It's okay.
Item number 11.
But I appear for the appellant.
I appear for the respondent number
But
6.
I beg to appear for the read petitioner.
Yes, sir.
But I am. This is my maiden appearance before this bench.
When
If other side,
yes, sir.
if other side is not prejudiced, my lord, can I get 1 day's accommodation to appear in personally as a maiden appearance?
We are not accustomed to see Mr. Basu appearing through online mode, but
he is otherwise busy today.
Yes,
that is why.
But the predicament is not a report which has been filed by the state authorities, not which has the effect of closing down my business. I run a garment shop in a closed cinema hall. It's Paradise Cinema Hall. Almost all the cinema, yes. It closed down in 2020. Probably all cinema halls in the city have been closed down largely. Not garment shops or malls have come down, have come up, or it has been developed.
No, you should apply for conversion.
There are two issues. Now, I have
Conversion
been
rejected
on the ground floor, but I had the trade license, I had the fire certificate, and by reason of an interim order passed in a civil suit, I was allowed to carry on with my business. Now, suddenly, not at the behest of some soda seller, and not somebody who stays 1 kilometer, obviously not at the behest of the developer, and in the civil suit. But there were complaints lodged. Now, the main issue is whether I am required to have a change of user apropos an old building following the old laws or the new laws.
100%. Because a theatre has to have a Form C license under the provisions of the Cinematograph Act. And their conditions are galore. And the district magistrate will conduct a personal inspection. Before that, you have to have a structural stability certificate. You have to have a certificate from the electrical inspector. You have to have a certificate from the fire safety department, fire department. And after following all that, then you give the Form C. If you see the annexure to Form C,
yes,
then the DM will come for an inspection. At those days, you have to have a fire bucket with sand. Nowadays, it is all automized.
The fast.
If you are running a shop in a cinema house Without conversion, it is unauthorized.
No, no, there are two issues. No,
Now,
the,
what did the learned judge do?
but the learned judge has directed the report to be implemented. I don't have a copy of the report. The fire department said that there are certain remedial measures, you carry out those.
Where is the report? Please show.
But I don't have the report. I asked for a copy.
Report has intentionally not my lord annexed.
But
It was circulated by the authorities.
Author of the report to supply us a copy of the same.
Everybody received
Who
it.
inducted you as a tenant?
I beg your lordship's pardon.
Who inducted this person, appellant, as a tenant?
Lord,
I'm not a tenant. I'm not a tenant.
I'm the lessee of the property. I'm the lessee of the property. I used to, my lord, run the cinema hall. Now, my lord, I have subleased a part of the property, retaining, my lord, some of the portion for my usage as the cinema hall. And, my lord, the remaining portion, my lord, recently, your lordship would find, my lord, various cinema halls, my lord, they have been converted in a manner.
Don't go by example, sir.
But that is
one
what I
illegality cannot make another illegality.
Right. Absolutely not. No, this is how the
Fire
structure
accidents
operates.
are galore in Kolkata because of this.
This
No,
is
no,
how
I
the
had a-
structure operates.
I had a fire certificate.
Nothing more than
I have a fire certificate.
You please show this document of the divisional fire officer.
So please come to page 51.
My learned friend is assisting me. He has a
Page
copy.
51,
Kindly show the
51.
551.
No, only 51.
51.
Yes. No, there are two pagination, one which bears the larger number. 3rd December 24.
From the inspection report by the concerned inspector of base of physical inspection notice, existing G+2 mercantile building along with commercial activities at the premises number Bentic Street, pertinent to mention building
Authority failed to produce any sort of fire certificate and fire safety certificate obtained from the fire department as so and so. The aforesaid matter is in violation of 11C. In view of the above, notice under section 35 is given to do certain things. But these are all remedial measures contemplated. I do that at page 48. On 16th of December 2024, I carry out these remedial measures at page 48. Or maybe it's running. Yes, page 48. No, it's just annexed in a reverse manner. It should have come later. But the larger page number at the top.
When you applied, when they applied to the directive.
On what date you applied for that?
But I got the fire certificate not in 2024. 2023, before that.
I'd like to inform that we had applied to the directorate through online.
Yes.
So and so for we had received the same copy of so and so is annexed.
That's page 49.
49.
Yes. It's valid till 7th of November 2025.
No, who applied? You could not have applied. The lessee should have applied. It is for, you please see type of occupancy, function halls, cinema halls, single screen malls, religious places.
Yes.
Not for a shopping complex. And who is the name? Applicant is Shubham Sharaf. The appellant is Prime Link. Prime Link Trade.
My authorized person.
Huh?
He's my authorized person. Now, please come to page 14. No, that's the issue note which is at large before the court now. 20th January 2025. The notice under section 35, not it refers to then with reference to the above service to inform you that a self-certificate under notification number so and so first may obtained by you with a unique number so and so based on furnishing inappropriate and improper data in self-declaration in respect of your occupancy in terms of floor area, height of building, nature of occupancy, etc. Hence, the above said unique certificate should be treated as invalid. However, on the basis of available official records, that is plan drawings, relevant documents submitted by applicant for the application to obtain fire safety recommendation, it is so and so was rejected for the following grounds. 1. Change of occupancy not approved by competent authority, inadequate side open spaces, kitchen shown in the mercantile portion on first floor. So these are the 3 grounds. Now, this is not a kitchen, this is really a pantry, not where the employees just...
No. You do one thing, you rectify these 3.
That's why I wanted to do this.
You close down and rectify. In between, the fire certificate, I mean, the authority says, in the meantime, if anything happens, you will be responsible.
Right.
What is all, whether you can save the lives of your...
So far as change of occupancy certificate is concerned, not there is already an interim order passed by this honorable court, approval not KMC having taken steps. But please come to the order. Not this.
So you can't operate on court orders, sir. You can't be operating on court orders. This is an issue not concerning the owner of the business. It's concerning the people who are coming to your premises, people who are doing activities,
right.
People who are walking on the road.
Now,
fire is an hazard, sir.
Right. Now, I'm not. Please appreciate this situation.
Of the fire license, withdrawal of the fire license is not even under challenge by him. He has not challenged it.
I don't have a copy of the report.
I do not want to interject.
Not the court.
I am
That
assisting.
is in the court.
This is the copy of the report.
That is in the court.
Please see,
But
not
can
the
we see this report?
On
Please
the,
see.
by an order dated 2nd of January, the learned single bench had directed the fire authorities to file a report. That is at page 67 of the appeal.
Yes,
brief.
please see pages 67 and
Thereafter,
70.
Report was filed on the next occasion. Report was directed to be circulated amongst the parties. But we have obtained the copy. We were the writ petitioner. I am led by Mr. Basu. With leave of Mr. Basu, I am making this.
Please come to 70, page 70. But I have a right to prefer an appeal from this order. A report is relied upon. The court directs compliance.
As of today, there is no fire. Can you run?
Change of, please have a look at sections 35 and 38. It's only remedial measures contemplated under the statute.
See, the license which you had applied for is an online license. So that to streamline, everybody has done that, including the municipal corporations. That is why they say that is a self-declaration. The declaration which you have given at the time of issuance of license, whether it's correct or not, will be revealed only at the time of inspection.
Right.
Now the officer says that there are anomalies,
incorrect,
self-certification, and the actual data review.
But that's exactly not what has been said.
You invoke the remedies available under this particular enactment. You go before the authority. You apply for the license or you change of user, etc., etc. Until then, you please.
But change of user is something not which probably it's beyond the competence and jurisdiction of the fire safety officer or not the department, because change of user is something which is contemplated in the KMC Act, and there is already a challenge thrown that there is no requirement of change of user in this case.
We find that there is no error in the exercise of discretion by the judge for the division bench to interfere against an interim direction, and the matter has been placed on 25th February.
No, it was a common. Please come to 2 pages, page 67 and 70.
Pending consideration, Director General.
Yes, now please come to 70.
Let copy be circulated.
And the owners, occupiers of the subject building a notice dated 20th January 2025 directing them not to use the same for the purpose of running any commercial activities of any type without regularization. Not, of course, not cinema hall is also a commercial activity. None represents the states. Learned Counsel representative submits that despite notice served by the divisional fire officer, the private respondent is continuing with the commercial activities at the said place. Fire safety services is directed to take immediate necessary steps to implement the direction passed in the notice for not using the for the purpose of running any commercial activity. It was being run for commercial activity.
You obtained a license based on a computer generated format.
But that's their format.
Please come. This intra-court appeal by the respondent.
The head letter 4 to 12. But I have nothing to do. But
All right. We will note your appearance. This appeal has been filed by so-and-so respondent in the WPO 1109 of 2024. The writ petition has been directed to be listed before the learned single bench on 25th February 2025, and in the meantime, taking note of the report filed by the director of by the divisional fire officer, South Calcutta Division, West Bengal, Fire and Emergency Services dated 21/1/2025, the learned single bench had issued certain directions. Firstly, we find that there is no error in the exercise of discretion by the learned single bench in issuing the impugned interim direction. Apart from that, we have to note that as on date, there is no fire license which has been obtained by the appellant for running a business, that too in a portion of a cinema hall, and the report also states that there is no order for a change of occupancy,
Change of user.
for change of occupancy by the competent authority. Apart from the learned senior advocate appearing for the appellant relied upon a fire license which has been obtained. Firstly, we note that the said fire license is obtained based on an online application, and pursuant on after inspection was conducted, the divisional fire officer has reported that there are anomalies between the self-certification by the petitioner and the actual data revealed during the course of inspection. Thus, we find no grounds to interfere with the impugned order. Appeal files
Only one humble submission. Preferred a statutory appeal from this communication. Lord, kindly direct them to dispose it.
25th we can take. 25th you get that order.
Lord, the direction is implement.
Of the writ petition.
But I don't know. Lord, the direction is
I'm
dispose.
grateful to man.
Implement this order.
Only interim.
Yes, if there is no appeal, it has to be implemented.
Yes, sir. So next is what is the direction?
Grateful to man.
All that alone.
And number 12.
I appear for the appellant. I appear for the appellant.
Where is the affidavit in
Affidavit, my lord. Here is the affidavit, my lord. May I submit the affidavit, my
This
lord?
was what
My lord, in this matter, my lord,
remains to be
I'm
done.
led by Mr. Advocate General, my lord, landed
Yes.
Advocate General, and he asked me to take time for at least 15 days, my lord.
Your lordships will fix this appeal for a hearing. If the learned advocate general wants 15 days, let it be 15 days, but let it be fixed, because my lord, there is some urgency here, because the issue is whether I am liable to pay stamp duty under the West Bengal Stamp Act in West Bengal, or whether I have to pay it in Uttar Pradesh. Now, if ultimately I lose and it is held that I have to pay stamp duty here, there is a question of set-off also. So everything has been stalled. It's in a limbo since 2023. Kindly fix a date on which the appeal can be heard.
Any day in the month of March, the first week of March.
in terms of the liberty granted in the order dated January 31, 2025, affidavit in opposition has been filed by the respondent, copy of which has been served on the learned advocate appearing for the appellant. Into fix. 28th March.
28th March.
Let the appeal be listed for hearing on 28th March.
28th March. Well, the only submission is because the stay petitions have been disposed of, not a paper book, but may we prepare a convenience compilation of all papers and we'll serve it on the other side.
Sir, please take down. Leave is granted to the learned advocate appearing for the appellant to prepare a convenience volume or convenience set, and the copy of the same shall be served on the learned advocate for the respondent state well in advance. Next.
Affidavit in opposition handed to be taken on record.
What is next? Who's filed the review? Yes.
Lordship, this is a review application. We have served, but it has been returned as not found. So, Lordship,
No. Here
we have instructions to appear, my lord. Let them serve.
What is the review you want? Where are
Contrary to law and contrary to the
Well, this is a review in respect of an order passed by my lord and Justice Bhattacharya.
that is correct? That we can't take it up. On what ground do you want a review of this?
Or the review is on the ground that your lordship were pleased to dismiss the appeal on the ground of threshold value. So, my lord, subsequently it has found out from the department's instruction that the appeal itself is above the threshold value. If your lordship allows me to come back on the next day, or as your lordship will direct, I shall try to satisfy.
No. In your grounds, you should have mentioned that.
Memo of appeal there.
Actually, we have instructions to appeal. Madam, we have kindly
serve
a copy.
Very well, I shall serve a copy and come back.
We will not say anything. We will say list. Before the you have to say that not required.
Copy party our deal.
Number 14.
This is that incentive matter. Learned Advocate General was
today, second half, there is some difficulty for me.
Very well, man. Then we will come back on next Friday.
Next Friday will be
subject to your lordship's kind.
21st.
21st or Wednesday week, whichever day.
21st.
21st.
Because otherwise, it should have reached by 11:15.
Because man, next Wednesday, man, I may be.
All right, 21st.
My lord. The matter may retain its position.
Yes, list on 21st in the under the same caption.
Great.
One matter you call 16.
Number 16.
What is this?
Yes, my lord, this matter relates to my lord, death of two young boys in an alleged accident. Now, my lord, the matter was directed that the matter is premature. Then the matter, my lord, Honorable Chief Justice, the then Chief Justice directed that the matter should be reviewed on particular points, that these are the aspects which has not been investigated. My lord, the order is, my lord, kindly come to page number 38 of the CAN application. My lord, page internal paragraph 6. We have heard the learned counsel for the parties and perused the record.
Page number?
My lord, 38 of the CAN application. CAN 1. CAN 2. My lord, the stay application. Now, my lord, Honorable Chief Justice, the then Chief Justice directed that the investigation should be conducted in a specific manner, and my lord, specifying the aspects on which the investigating authority did not throw any light. Now, my lord, the matter was remanded back to the Honorable Single Judge. Now, my lord, Honorable Single Judge directed that he has not prima facie found anything, but he is, my lord, relegating the matter to CID. Now, my lord, what CID has done, my lord, as if they have passed.
No, after remand, an order has been passed.
Yes.
That is impugned in this.
That is impugned in this order, my lord. Now, my lord. Yes, my lord, this Honorable Single Judge has, my lord, directed that since it is a matter of death of two young boys, let the matter be reinvestigated by the, my lord, the order is at page number 47. My lord would found that.
Yes.
Yes. Now, my lord, what the CID has done is as if they have passed a recent order. They, my lord, kindly come to 69, my lord, without conducting any investigation, anything. They have only affirmed that whatever the FST, the previous investigating officer has done is right. They have not at all dealt with the allegations raised by this petitioner, my lord. I can show, my lord, here and now from the pleadings that, my lord, how far the investigating authority has only tried to prove that this is an accident without doing anything. Even till date, the wearing apparels, the mobile phone of the second victim is not recovered.
Now, this report has been filed before the learned Chief Judicial Magistrate, Alipur.
Yes, my lord.
What is the remedy available under the erstwhile Criminal Procedure Code?
My lord, erstwhile Criminal Procedure Code, my lord, there is, my lord, under 173, the judicial magistrate can only direct for reinvestigation, not change of the officer. Nothing
Can't
can be
send
done.
it to CBI and all, sir.
No, my lord, I'm not. We are not asking for CBI. All we are asking that, my lord, let an independent officer of this CID let only, my lord, throw light on the aspects.
No, you please invoke the remedies available under the.
But my lord, they do not have the magistrate, learned
Malad, may
magistrate.
I interject? Malad, actually what has happened, Malad, previously the police was investigating. During the investigation stage, we approached this honorable court saying that these are the defects in the investigation done by the police. Now the jurisdictional magistrate is Alipur from the police department. Malad, we have taken all the copies from there and we have tried to agitate that the investigation which has been done by the police is not in a transparent and fair manner. Because the mobile phone
can order for reinvestigation.
Yes, Malad.
And it can also say that the same officer should not do it.
Lordship.
So you have to invoke.
Malad, over here, my legal difficulty will be that before the Alipur court, the police, the Kolkata police who has investigated the matter is reporting before the Alipur concerned magistrate. Now, with the single bench giving us liberty to approach the CID, Malad, we have given all our materials before the CID. Now, the CID has not done any investigation. Now, over here.
Now, what is the stage of the charge sheet filed by the state police?
Well,
by
the
now,
charge sheet is
now
only...
the case would have been ripe for trial.
Well, over here, the defects are such.
No, the learned single bench says, if CID comes to a new finding and our viewed persons may be involved in the incident, they shall liberty to file independent charge sheet.
Yes.
In such an event, charge sheet already filed by FSTP, Lal Bazar, shall be in abeyance. Now they have not come to. So their charge sheet will get activated. Trial would have commenced 20.
Well, over here, the trial is in respect of only.
Mr. Banerjee can do one thing. We will dismiss it. You go there.
Well,
because we can't.
Well, kindly see then what are the points we have taken. The defects. Well, these your lordship knows the Supreme Court.
This is the maximum a red court can do. It is not as if you are without any remedy. It is very sad state of affairs, of course.
Because 2 children has died on the same incident. Now the recovery of mobile phone. Kindly see. Kindly 49. We have just page 49 onwards of your lordship's brief. Kindly see. This lady is also a chambermaid. We have been continuously pursuing the same so that she has some solace in his hand.
Conductor has not been interrogated.
Kindly see the details, call details, everything we have written.
Who will appear for the state?
Well, previously, Mr. Banerjee, senior Mr. Banerjee, Amitesh Banerjee was appearing. Now,
Srishan Bandopatya.
Yes, Malad. Well, do he put him on notice? Malad, these are the things. We do not want any CBI or anything. A CID responsible officer may relook into the matter.
CCTV of the same crime as
The elder son mobile phone was not seized properly. It was later.
Then statement was recorded from the mother.
Yes.
But she could have very well said once again the red court. Where is the question of?
Well, she has said everything. Whatever there is in the pleadings.
The learned advocate appearing for the appellant is directed to serve the learned advocate appearing for the state. List next week. Let us see.
Lordship, deeply obliged. List for the
My lord, there is a matter, my lord, which we filed with your lordship leave without certified copy yesterday. Now I am told that without the certified copy coming in the file itself, it will not be listed on Tuesday. So, my lord,
you give the copy application number. We will ask them to issue it.
On Tuesday, my lord, this Tuesday, my lord.
No, they will issue that. You ask them to issue certificate copy.
No, we are pursuing, my lord. We are pursuing to get.
We will also pursue on your behalf, so that you get it early.
Grateful, Lord.
Then we'll do something.
Grateful.
This is a group 9 matter.
No, my lord. It is a group 4.
4. Tuesday it has to come.
Tuesday.
We'll do something today afternoon.
Grateful.